We want to talk more about this maritime boundary dispute, and we want to cross over to our I&M studios for that interview, and we will be discussing just some of those issues that are emerging. Remember that this is, we've seen the Attorney General as leading counsel at the International Court of Justice, that's the ICJ, I beg your pardon. And now we have Musili Wambua, who's a professor joining us from our City Center studio. Thank you, Professor, for joining us. Let's begin with breaking down for many of our viewers, as far as the genesis of this. What is this maritime boundary dispute really all about in simple language?
Thank you very much, Sophia, for inviting me to the studios to comment on this topical issue. First and foremost, I need to make a clarification, which I think is very essential for the viewers to appreciate. I read in one of the articles that the ICJ, or International Court of Justice, is being referred to as the ICC. I think it is important to make a distinction between these two courts. We are familiar with the International Court of Justice as a judicial body, the main judicial body established under the framework of the UN to hear disputes between member states. The ICC is a different court, although both of them are located at The Hague, and the ICC deals with international crime. So it is actually a focus of international criminal justice, and that is a court which we are familiar with because Kenya did have some of our citizens tried there fairly recently. But the dispute involving Kenya and Somalia arises within the framework of international law, specifically the law of the sea. And it involves the demarcation of maritime boundary to the north. And the genesis of this dispute goes back to 2005, following a presidential proclamation which set the boundary to the south with Tanzania and to the north with Somalia. After that proclamation, a lot of events took place in 2009, and Kenya did submit a claim for extended continental shelf. And this extended continental shelf was again done within the framework of the Law of the Sea Convention, and that convention allows a state to claim up to 350 nautical miles of continental shelf. The first 200 miles are given as of right because they are coextensive with the exclusive economic zone. But if a state wants to claim an additional 150 nautical miles, then there is a procedure, a special procedure to be followed, which requires the state to deposit maps and charts and scientific data and information supporting the extra claim. Once that was done in 2009, then Somalia objected, and the matter was referred to the Commission on the Limits of the Continental Shelf, and it's still pending there. In between, there were negotiations between Somalia and Kenya to reach amicable settlement with regard to the extended continental shelf and other maritime disputes involving the territorial sea and the exclusive economic zone. Those negotiations failed because in one such meeting, Kenya did not turn up, and Somalia took the view that Kenya was not negotiating in good faith, and therefore referred the matter to the ICJ in 2014.
We've heard from Kenya's legal team is reference to an MOU and a memorandum of understanding that, according to Kenya, really settles this matter. And the question and the matter and the issues they've been raising to the court is that Somalia really should stick to the issues that were agreed upon and not seek to renege on the same. So from where you sit, this MOU and Kenya's argument vis-a-vis what we're hearing from Somalia, which side do you lean on?
Well, let me put it in context. First and foremost, the point which you have referred to is one of the points which have been taken by Kenya as a preliminary point touching on jurisdiction and admissibility of the claim. Now, the Law of the Sea Convention requires states, Article 15 and Article 74, to agree on disputes. Agreement is the very first step. And where there is an agreement between states, then the jurisdiction of the court is to some extent ousted, in the sense that parties have preferred agreement. Now, the MOU we are referring to in 2009 was reached between Kenya and the transitional federal government, which was then based in Nairobi. And immediately after that MOU was reached, there was a repudiation by Somalia, and on the ground that the particular minister who signed the MOU did not have authority to do so. Well, that is a moot point because it goes to other details as to whether indeed there was authority and whether indeed at that particular time the transitional federal government was a government. In my own view, there was a proper agreement reached between Kenya and Somalia. And therefore, the point Kenya is taking is that since there was an agreement, this claim by Somalia is not admissible within the jurisdiction of the court, and therefore the two parties or the two states should proceed on the basis of that MOU of 2009.
All right. And also, we have seen Somalians argue that the reason they resorted to the International Court of Justice is because they got the feeling and the sense that Kenya was behaving like a big brother. And I remember earlier you mentioned something about Kenya not showing up to some of those meetings and as far as negotiations were concerned. So is it, from your perspective, a situation where Kenya really has mishandled this matter in as far as meetings that have come before that would have allowed for them to resolve the issues and not allow for the matter to go as far as it has?
My view is that the last meeting which Kenya did not attend in Mogadishu was around October 2014. And 2 days after that meeting, Somalia was already at the International Court of Justice. And one, of course, raises a concern as to whether indeed Somalia was negotiating in good faith, given the fact that within 2 days the matter had already been referred to court. Well, that is not to say that there was no laxity on the part of the Kenyan side in following up on those discussions. But the points Kenya is raising as a way of preliminary objection with regard to the submissions which are being concluded today, I think in my own mind they are very strong. The first point Kenya is raising is the historical claim to those zones, which, of course, take in the blocks referred to as L21, L23, L24. And those are huge blocks which, of course, are rich in oil resources and gas. And therefore, that claim of historical and contested historical jurisdiction, to me, I think may not hold water, given the fact that at one time, in fact, Somalia did claim a territorial sea of 200 nautical miles, and that, of course, extended to cover that area in dispute. So the question of historical claim is a fact which has to be proved before the court based on evidence, but in my own view, it is not very strong. However, the issue of jurisdiction and admissibility, I think Kenya has a very strong point, in the sense that there is this MOU, which to some extent hosts the jurisdiction of the court. The question of agreement between the two states, of course, takes preference within the framework of the Law of the Sea Convention, and therefore should be given an opportunity. There is another point which Kenya has taken, which is, of course, very important, and that is none of the two states, Kenya and Somalia, has exercised or has filed declaration to choose a forum. Within the framework of the Law of the Sea Convention, states are required to file choice of forum in the event of dispute. And the forums which are stated are the international, what we call ITLOS, International Tribunal on the Law of the Sea, which is based at Ampag, International, of course, Court of Justice, which is based at The Hague, or a choice of an arbitral tribunal under Annex 7, or a special tribunal. None of the states, Kenya and Somalia, have opted for a forum. And therefore, that is also a moot point. The fact that Somalia is dragging Kenya to the ICJ and forcing a forum on Kenya, to which Kenya is disputing. So that is a fairly strong point. And my own view is that the preliminary points Kenya is raising are fairly strong, and therefore the court is very likely at one point to find in favor of Kenya. The last point on that is the question of whether, in fact, the court itself has the capacity to deal with the issues of demarcation. That is a reserve of the Commission on the limits of the outer continental shelf. And the Commission has the capacity, has the technical know-how, and therefore the court may take the view that before the dispute is heard by the court, an opportunity be given to the Commission to hear those scientific issues and technical issues which the court may not be prepared to handle at that stage.
All right, Professor, before I let you go, and very briefly, kindly help us understand what are the possible likely scenarios from this ICJ ruling, because of course we know at stake here the minerals, oil and gas deposits, but in as far as what we are likely then to hear from this court at the end of this matter being heard, briefly, what are those scenarios?
Well, the first scenario is the court to uphold Kenya's position with regard to the preliminary objection. And if that happens, then the matter is likely to be taken back to the Commission on the limits of the continental shelf for determination. The court is also likely to uphold Kenya's objection based on the MOU, in which case the court would order that the parties pursue negotiations and complete the settlement of the dispute using negotiations and an agreement. The court may take the view that, and this is another scenario, that the Kenya's arguments on the preliminary matters are not very valid, and therefore the dispute should proceed. And once the dispute proceeds, then of course the court will have to hear the matter and determine the matter in the normal way. And it would be dependent on precedent. I mean, this is as a court. This court has decided other similar cases. We have Nigeria and Cameroon, Qatar and Bahrain. We have the Greenland case versus Jan Mayen. We have Honduras and Nicaragua. All these have decided the issues of maritime dispute, which are similar to this. But my view is, in the long run, if the case is heard and determined, the likely result is that the court may find in favor of an equidistant line which is argued by Somalia, unless Kenya can show special circumstances which requires that we deviate from that line. And these special circumstances include the length of the coastline, distribution of the resources, and historical claims which Kenya is arguing about.
All right. Thank you so much, Professor Musili Wambua, for joining us on News Center this morning and for giving us perspective on really the underlying issues and likely scenarios out of this Kenya-Somalia row over the maritime boundary. A story we'll continue to follow and bring you updates as we get them. To our top story now, former